A single tax rate drop to $0 might have just accidentally dismantled 90 years of federal gun control. Since 1934, the federal government has heavily regulated suppressors and short-barreled rifles, not through outright bans, but through the constitutional power to tax. But when Congress slashed those specific taxes to $0, they created a massive legal paradox. In the landmark federal lawsuit Roberts versus the Bureau of Alcohol, Tobacco, Firearms and Explosives, gun rights advocates argue that a tax of $0 collects zero revenue, stripping the government of its authority to maintain its registry. Now, the Department of Justice is launching a desperate defense to save federal gun control from its own tax code. To understand the gravity of this challenge, we have to look back nearly 9 decades. For this long stretch of American history, the federal government maintained a tight grip on highly regulated firearms and accessories through that specific constitutional mechanism, the power to tax. When the National Firearms Act was enacted in 1934, Congress did not outright ban items like suppressors, short-barreled rifles, or short-barreled shotguns. Instead, they imposed a heavy tax stamp, a move the Supreme Court subsequently upheld because it fell under the federal government's authority to collect revenue. But what happens to that regulatory framework when the tax itself disappears? This is the central question driving the major federal lawsuit, Roberts versus the Bureau of Alcohol, Tobacco, Firearms and Explosives, filed in the United States District Court for the Eastern District of Kentucky. Brought by a coalition of individual gun owners, firearms businesses, and civil rights organizations, the case targets the very foundation of federal gun control. The plaintiffs point to a critical shift. Congress recently reduced the making and transfer taxes for these specific items to $0. The legal logic of the challengers is straightforward but potentially devastating to federal oversight. They argue that if the tax is $0, there is no revenue to collect, meaning the taxing power can no longer justify the law. Without that constitutional anchor, the entire apparatus of the National Firearms Act, the mandatory registration, the lengthy approval wait times, the transfer restrictions, and the severe criminal penalties, loses its legal justification. To the plaintiffs, a tax of $0 means the regulatory gate must swing wide open. Yet the Department of Justice is mounting a fierce defense. In a newly filed final reply brief before the court rules on summary judgment, federal prosecutors laid out a comprehensive blueprint designed to protect the registry at all costs. The government is not merely defending the tax, they are attempting to shift the entire constitutional battlefield. This defense begins not with the grand constitutional questions of the Second Amendment, but in the weeds of civil procedure. The Department of Justice knows that the cleanest way to win a lawsuit is to prevent it from being heard at all. In its final reply brief in the Roberts case, the government's opening move is a calculated attempt to shrink the opposition by targeting one of the key organizational plaintiffs, the American Suppressor Association Foundation. The Department of Justice is asking the district court to outright dismiss this foundation from the lawsuit, invoking a technical legal doctrine known as claim splitting. According to the government's filings, the foundation is attempting to litigate the exact same National Firearms Act regulations in Kentucky that its closely related sister entity, the American Suppressor Association, is already challenging in a separate federal lawsuit in the state of Missouri. The legal system generally prohibits plaintiffs from running duplicate lawsuits in different jurisdictions to resolve the same dispute, a rule designed to protect judicial efficiency and prevent conflicting rulings. But this procedural maneuver is about much more than administrative efficiency. By attempting to disqualify the American Suppressor Association Foundation, the Department of Justice is executing a classic defensive strategy, pruning the battlefield. If the government can successfully remove major organizational plaintiffs, they reduce the resources, standing, and legal reach of the opposition. It is a high-stakes game of procedural chess designed to neutralize key players before the judge even begins to evaluate whether a $0 tax invalidates the National Firearms Act. If the government succeeds in this initial skirmish, it could leave the remaining individual plaintiffs to carry the constitutional fight alone, significantly altering the dynamics of the case. This procedural shield is only the first layer of the government's defense. setting the stage for an even more aggressive reinterpretation of federal taxing power. Once those procedural skirmishes are established, the Department of Justice pivots directly to the core constitutional battleground, the survival of the taxing power itself. The plaintiff's argument seems elegant in its simplicity. If Congress reduced the tax on making and transferring these firearms to $0, the constitutional hook is gone. But the government's defense exposes a complex, interconnected web of federal taxation that most casual observers overlook. The Department of Justice argues that the National Firearms Act does not rely on a single, isolated tax. Instead, it is supported by a broader structure of revenue collection that remains very much alive. Specifically, federal prosecutors point out that while the making and transfer taxes for individuals may now stand at $0, Congress did not dismantle the entire tax apparatus. Importers, manufacturers, and dealers of National Firearms Act items are still subject to a distinct financial levy known as the Special Occupational Tax. To the government, this is the critical anchor. They argue that the extensive registration requirements, the detailed database, and the rigorous approval processes are not arbitrary hurdles. They are administrative tools directly necessary to enforce and collect this remaining special occupational tax from commercial entities. In essence, the Department of Justice is telling the court that you cannot isolate the $0 tax paid by an individual buyer from the taxes paid by the businesses supplying them. The registry exists to track the flow of inventory, ensuring that commercial operations are accurately reporting their activities and paying their required dues. If the court accepts this logic, it means that as long as a single dollar of tax is collected anywhere in the supply chain, the entire regulatory framework of the National Firearms Act remains constitutionally authorized. This argument creates a formidable barrier for gun rights advocates, shifting the debate from the power to tax to the power to regulate commerce. If this primary taxing power argument fails to convince a skeptical judiciary, the Department of Justice has constructed a massive constitutional backup wall. They argue that even if a court rules that a $0 tax completely strips the National Firearms Act of its taxing authority, the entire regulatory structure remains perfectly constitutional under a completely different provision of the United States Constitution, the Commerce Clause. According to the government's final reply brief, the market for suppressors, short-barreled rifles, and other highly regulated firearms does not exist in a vacuum. Instead, manufacturers, distributors, retailers, and individual buyers all participate in a highly integrated, national interstate market. Because these items constantly cross state lines and affect the national economy, federal prosecutors assert that Congress has the authority to regulate, track, and restrict them under its power to regulate interstate commerce, completely independent of any tax collection. This shift in strategy is highly significant. It reveals that federal prosecutors are actively preparing for a future where federal judges, who are increasingly skeptical of expansive federal powers, might strike down the taxing power justification. By establishing the Commerce Clause as a secondary defense, the government hopes to insulate the National Firearms Act registry from any single judicial blow. However, this backup defense is far from secure. The scope of the Commerce Clause is currently one of the most hotly contested battlegrounds in federal jurisprudence. In fact, the United States Court of Appeals for the Fifth Circuit is actively reviewing this exact issue. This judicial scrutiny follows a direct call from Supreme Court Justice Clarence Thomas in a recent decision where he urged lower courts to re-examine the limits of the Commerce Clause in relation to federal gun control laws. If the courts decide that the federal government has overreached its commerce powers, the Department of Justice's backup defense could crumble, leaving the National Firearms Act vulnerable to a historic defeat. But the government is not stopping there. They have one final, sweeping defense that directly targets the Second Amendment itself by attempting to reframe the entire nature of the registry. In this final line of defense, the Department of Justice addresses the direct Second Amendment challenge raised by the plaintiffs. To counter the claim that the National Firearms Act infringes on the constitutional right to keep and bear arms, the government relies on two distinct strategies. First, they deploy a familiar historical argument, asserting that short-barreled rifles and short-barreled shotguns have historically been subject to stricter regulation because their concealable nature made them uniquely associated with criminal activity. But it is their second argument that represents a bold, highly controversial legal maneuver. The Department of Justice is urging the court to view the entire National Firearms Act not as a restrictive ban, but merely as a shall-issue licensing system. They are drawing a direct parallel to the landmark Supreme Court decision in New York State Rifle and Pistol Association versus Bruen. In that case, the Supreme Court struck down discretionary carry permit schemes, but explicitly approved of objective, shall-issue licensing systems for concealed carry. The government argues that the National Firearms Act operates on the exact same principle. Under their logic, because the Bureau of Alcohol, Tobacco, Firearms and Explosives must approve an application if the applicant meets the objective criteria, the registry is nothing more than a regulatory licensing scheme. The plaintiffs strongly reject this characterization, arguing that the National Firearms Act is a restrictive registration regime designed to deter ownership through extreme delays and severe criminal penalties. However, the Department of Justice maintains that requiring prior government permission to make, transfer, or possess these items is no different than requiring a permit to carry a handgun in public. By attempting to rebrand the National Firearms Act as a routine licensing system, the government hopes to shield it under the Supreme Court's own precedent. What makes the Roberts case such a critical turning point is not merely the individual arguments, but the fact that the Department of Justice has now laid bare its complete, unified blueprint for defending the National Firearms Act nationwide. This is not a localized, one-off defense. Federal prosecutors are facing a coordinated wave of litigation, including high-profile challenges like the Brown and Jensen cases, alongside major industry-backed efforts from organizations like Silencer Shop. In response, the government has constructed a highly sophisticated, multi-layered legal fortress designed to survive the post-Bruen era. To understand the power of this blueprint, one must look at it as a cascading system of legal redundancies. The Department of Justice has built a defense where each argument acts as a firewall for the next. If the district court rejects the procedural attempt to dismiss the American Suppressor Association Foundation, the government immediately pivots to the tax preservation argument, pointing to the special occupational tax paid by commercial entities. If the court rules that a $0 individual tax invalidates the taxing power justification, the government falls back on the Commerce Clause, arguing that the national market for these items inherently allows for federal regulation. And if the court rejects that commerce authority, the Department of Justice deploys its final, most controversial shield, rebranding the entire registration system as a routine, constitutional licensing scheme. This structural redundancy is a deliberate strategy to prevent a single adverse ruling from triggering a domino effect that could dismantle the federal registry. By presenting these arguments in a single, comprehensive filing, the government is attempting to establish a precedent that can be copy-pasted into every federal court across the country. The Department of Justice is signaling that it will defend the registry at all costs, using every constitutional tool at its disposal. But this aggressive defense also raises the stakes, forcing the courts to rule on these sweeping interpretations of federal power. Ultimately, the Department of Justice's blueprint reveals a critical truth. The federal government will not let the National Firearms Act fall without a massive, multi-front legal war. By shifting their defense from taxing power to the Commerce Clause and shall-issue licensing, federal prosecutors are trying to ensure that even if the individual tax remains at $0, the registry survives. As the Eastern District of Kentucky prepares its ruling, this legal battle is far from over. Whether these historic regulations stand or crumble will ultimately depend on how federal judges define the limits of constitutional power in a post-Bruen America.